good thing I'm such a technological whiz.
I think people were having issues today as well. Something's going
I don't know.
on.
I don't know. This is my first OA back after, the break. So maybe it's just my vibe. Okay. Who's up? Mr. Bannon, you're up.
May it please the court, Tyler Bannon on behalf of the appellant Hannah Brazelton. I would request 5 minutes for rebuttal, please.
Sure.
This appeal comes before the court after a judgment in a non-jury trial against Mrs. Brazelton and in favor of Student Loan Solutions. I believe this appeal involves a relatively straightforward issue for the court's consideration, specifically that the trial court erred in finding that the claim was not filed significantly outside of the statute of limitations when the overwhelming majority of evidence presented established that the debt was accelerated as early as September of 2014.
Well, let me ask you what that standard is, Mr. Sure. Bannon, because there was ultimately a Dunn letter that says we are hereby accelerating. And all the previous ones didn't say that.
Correct.
It's the standard under California law, which you propose that we write an opinion under California law. Is it the consumer might think this was an acceleration versus what was the legal effect of the terminology? I mean, what is the standard here?
The standard, it is California law and Florida law have some very much similarities.
Don't tell government takes place.
But the standard here is in the Trigg case. It's Trigg versus Arnott, 22 California Appellate 2nd 455. And basically in that case, it shows how our Bartram opinion doesn't mix with California's standard. And in that opinion, it shows that even when a promissory note contains a non-optional acceleration clause, meaning that upon the triggering of the event that would make it acceleration, it still is still an optional acceleration clause. So even if per the contract, it applies right away, it doesn't apply unless and until, and this is in under California law, the holder of the note takes some affirmative step to put the debtor on notice that the acceleration clause has been accelerated, has been taking place. So it just takes.
Okay. So, and that's the question, to put the debtor on notice. I mean, is the judge evaluating, the debtor might think this was an acceleration? Or based on the evidence of, how the parties conducted themselves and, what the intent of the Dunn letter was, the judge makes a determination that this was a step that accelerated or not a step that accelerated.
Well, I think it comes from the holder's perspective, what they're doing, their affirmative step to try and.
So the holder in this case says, we didn't accelerate. And they point out that language in the Dunn letters that said what the, to say balance due or balance owed, that was in compliance with the federal law that required them to put that total number there.
Well, and again, that total number is the accelerated number. So whether they want to capture,
except they make I think a pretty fair point that as they sent these successive letters, the number wasn't increasing with interest. So that was like the total, soup to nuts amount that would be owed under this obligation.
Correct. And the representative testified at trial that the amount that they were demanding was well above the installments that would have been due at the time. It included all the principal
at the time. I get it. I hear what you're saying, but they're also saying that federal law required them to put that number there.
Well, and I think Your Honor is pointing to the FDCPA, the Fair Debt Collection Practices Act argument that the appellee has made, which they never raised in the trial court. Never.
Right. Tipsy Coachman.
I understand. But the FDCPA doesn't require that information on every communication. So 1692 subsection G is the validation requirement under the FDCPA. It requires that within 5 days of the initial communication, or it can be in the initial communication that they provide certain type of information.
Right. And one of them is, how much is this total obligation?
but every other communication doesn't require that information. And by definition, the FDCPA applies to debt collection. So if you're attempting to collect a debt, it would be subject to the FDCPA. And not only withstanding, the FDCPA is not here to protect debt collectors. It's there to protect consumers.
I get it. I get it. I get it. But I come back to the question. What is the court? How is the court supposed to apply these general principles? You haven't given me a case that involves this scenario. You gave me the general principles of from the federal court as quoting the state court, but is the judge supposed to say, okay, a debtor of I assume reasonable experience and intelligence might think this was an acceleration, and therefore that's a step that accelerated the debt? Or is the court supposed to take into account all the circumstances in the law and say, well, no, this was not the creditor taking a step to accelerate?
Yes, I think it would be based off of the facts and circumstances, because California law only requires some affirmative action. So there's not a requirement that they use any special language like saying acceleration. I know that was a point that was made to the trial court, that none of these other letters say acceleration. Well, you don't have to say acceleration. It's not required by the law. It's the form over the substance of that. That's what they're trying to put in, the form over the substance. The substance of the communications squarely put everyone on notice that they were demanding and attempting to collect an amount of money that would not be due absent acceleration. And if paid, and I think this is the most important piece of evidence, is that the representative stated that had they paid the $30,548.99, it would have fully satisfied the obligation under the terms of the contract.
Well, certainly it would have, because that's what the contract said. But had they called up and said, listen, I can pay you $100 a month, and they would have said, okay, the letter can be read to be saying, please call us and let us help you deal with this.
Well, certainly, I guess the letter can be said to provide other options. I don't believe any of the letters provided an option to start making installment payments again.
No, but the letter said, please contact us and help it, and so we can try to work this out.
Correct. And the other quote directly from the letters is that they were sent to collect the total amount from you in connection with a delinquent debt, which, again, I'm not sure how, if you're trying to collect the total amount due on a delinquent debt, how that is not per se acceleration. And I believe that the appellant's answer brief takes a lot of
you're
time.
suggesting, and let's get practical here, Mr. Manning, that we write an opinion under California law that says a done letter that includes the total amount owed under the obligation is going to be an acceleration such as to trigger the running of the statute of limitations. You haven't given us a case that says that from California.
Just the Trigg case is the standard that we go under. And unfortunately, we don't have any cases directly on point from California.
Right, which would be a good place to find some.
Well, I think their standard is just very different than ours. Obviously, Florida has the Bartram opinion, and we have that there are even if an account is accelerated, each one follows its own statute of limitations breach. That doesn't contain here. It specifically says that if you take some affirmative step to put the debtor on notice that you're accelerating by attempting to collect the entire amount of the debt, then that is by definition the acceleration. And then the penalty there is that while you're able to try and collect amounts that wouldn't otherwise be owed under the terms of the contract, you do have then 4 years to file the suit. And I believe that
Mr. Bannon, you're at 5 minutes to go, so use them as you please.
5 minutes to go before my
no, 5 minutes of your total time. You're into your rebuttal time is what I'm saying.
Okay, I'll pause there.
Okay.
I'll simply say that what our remedy is seeking is reversal of the trial court's opinion, and not a new trial or time for new evidence. Everyone presented their evidence. Everyone relied on their arguments and whatnot. There's no evidence that was not admitted that we're arguing today. So the remedy here is not for a new trial, but for judgment to be reversed and put in place against the appellee and in favor of the appellant. Thank you.
Thank you. Mr. Grassi.
Thank you, Your Honor. May it please the court, David Grassi here on behalf of Appellee Student Loan Solutions. I'd like to touch briefly on the standard, talk both in our briefs about competent substantial evidence standard of review. Florida Supreme Court's clear that the court must assess the record for sufficiency only, not its weight. And the Fourth District Court of Appeals in Taylor v. Richards says in a bench trial, as this trial was, trial judge's findings will not be disturbed unless the appellant can demonstrate.
Well, although if the evidence is in writing, the law also says that the appellate court is in about the same position as the trial court to interpret written documents.
Sure, but
and there was no other evidence. I mean, the debtor didn't get on the stand and say, "Oh, I thought they were wanting the whole thing right away," right?
Correct.
This was strictly on the basis of the document.
Correct, Your Honor. And
so, so the question that I put to Mr. Bannon, and I'll put to you, and I think you probably know how you ought to answer, is a judge going by what the debtor might think the letter means, or what the the legal impact of the language is under the facts?
The latter, Your Honor. There are two cases we cited in our brief. One is In re Crystal Properties from Ninth Circuit, which is interpreting acceleration under California. Says the option to accelerate must be in a manner that is clear and unequivocal. And in that opinion, it's quoting an Eighth Circuit case, First Bank Investors Trust versus Tarkio College, says if there's a reasonable doubt as to the meaning of the terms employed, preference should be given to the construction which will prevent acceleration. So, but will prevent acceleration. But that's generally, I mean, we're kind of flipped here than the usual case. This is acceleration for purposes of statute of limitations, which would, in this case, the interpretation that it's an acceleration would favor the debtor. But typically, if the debtor is saying you didn't accelerate, so you can't collect the whole debt now, it's the opposite in terms of the effect of the legal ruling. Correct? Yes, Your Honor. Use a baseball analogy. Baseball tie goes to the runner. Here, tie goes in favor of not accelerating.
Okay. Or as I read in the sports news, we're going to have a continuation of a Red Sox Blue Jays game where one player might appear on both rosters in the same game coming up. So
if I may, Mr. Grassi, is it your position then? Because I'm pulling some of the exhibits that were provided to the court, the old letters. And quote, we were hired by Student Loan Solutions to collect the amount owed, quote, in order to clear the outstanding account. You may contact the undersigned or send the balance due to the above reference office, and then goes on. So is it your position that they have to use the magic word, that the acceleration? I realize in 2022, they did prepare with the language that this serves as an acceleration. Why wouldn't that not be, if you don't need to use the magic word? If you look at in order to clear the outstanding account, can that be construed as this is an acceleration?
We don't believe so, Your Honor, for a couple of reasons. One, it says we've been retained to collect the total amount. It does not say the total amount needs to be paid now. And then it goes ahead and gives options to the recipient of the letter on how to pay. And so they certainly have the right to pay the full balance at any time, but they also contact and set the payment plan. And it doesn't say that it identifies what the total amount owed is, but doesn't say that amount is currently due and owing.
In this
well,
context,
it does say, and in fairness, I'm sorry, go ahead, Mr.
Remind me, these letters were part of write-offs?
They were sent post charge-off, Your Honor.
Okay.
But again, and I'm having trouble because you guys haven't given, or nobody's given me something. What is a judge supposed to decide? Is a judge supposed to decide that there's language in this letter that could cause a consumer to believe it's been accelerated? Or is the judge looking to see, did the lender or collection agency intend to accelerate and use some language that made some, was just enough to accomplish the acceleration? What is the judge supposed to decide?
It's we believe it's the latter, Your Honor, and I think I need to make a distinction. You all know that these letters were sent by a collection agency. The law in California is that
the holder has to take an affirmative action. Williams and Fudge was a collection agency, never the holder. And we made some reference to agency in our brief. These letters themselves cannot constitute apparent authority, and there was no other evidence presented of any authority of Williams and Fudge.
Right, until William and Fudge, the collection agency, said, it's accelerated.
Right, but that was in conjunction with testimony from a representative from Student Loan Solutions that said, one, that was intended to be an acceleration letter, which either is evidence of actual authority, which we believe it is, or evidence of ratification. So either way, that letter would be binding on the principal.
But you guys, you have no problem with that, because it's not that letter that is causing you aggravation at this point under the statute of limitation.
Correct, Your Honor, but that letter is also clear and unequivocal.
So do you have any case where under circumstances like this, the court has said, well, because the consumer might have believed they were accelerating, it was accelerated, and therefore the lender can't come in more than 4 years later?
I'm not aware of any case that says.
So we would be writing the seminal case for the state of California if we reversed.
I'm not sure California would see it that way, Your Honor, but
wouldn't be the first time.
But following up earlier on Judge Northcutt's point, the latter approach provides a clear, bright line rule.
Yes, Your Honor, and we believe that
if you're using what might the consumer think, going back to an earlier stage before trial, you would never get summary judgment would just be off the table. Because I can imagine you're always going to have a factual issue as to what the consumer's intent was, as opposed to what the lender's intent was.
Correct, Your Honor.
Right. And in this case, Ms. Brazelton didn't testify. I got this letter and I thought they wanted the whole thing. Right? She didn't testify.
She did not testify, and the transcript does not even indicate that she was present at trial. Right. And I would submit that if it was some sort of subjective belief of the letter recipient, then it would open the door to a consumer or a borrower making an unreasonable belief and a creditor being bound by that.
So based on the evidence in our record for the appellant to win, its test would have to be some consumer who received this letter might think, based on this language, correct?
But that would also suggest that that was the standard, which we don't believe it is. We believe it.
Well, I understand what you're saying, but for the appellant to win, that would have to be the standard that the judge, the trial court would have to apply.
Yes, Your Honor, and that's why we don't believe that standard to be a workable standard. And I would note the United States Court of Appeals for the Fourth Circuit, the United States versus New Dye, said, in a literal sense, the tire principle could be due only if a note had been accelerated. A more sensible view, however, is that there is always an obligation to repay the entire principal that is due, though not immediately. So to me, that's, for example, I have a mortgage. I owe the full balance, but I don't have to pay it right now. I can pay it in monthly installments. So identifying the full balance does not say that they're enforcing any sort of acceleration clause. It's just identifying the total amount that I owe, which I always owe under the note unless and until it's paid. And I think it's important to kind of address the difference between acceleration and charge-off. Ms. Brazelton in her brief suggests they're synonymous, but they are not. They're similar concepts, but they really deal with separate relationships with one exception. Acceleration deals with the relationship between a creditor and a borrower, and is the creditor exercising its contractual right to declare the loan due now. Charge-off deals with the relationship between a creditor and a regulatory authority, and if a creditor believes a debt to be uncollectible, it permits them to essentially charge it off and get it off their books as an asset. This was recognized by the Fifth District Court of Appeals and Centennial Home Trust Company of Elizabeth versus Lippincott, said the process of charging off a loan has nothing to do with contacting the debtor and demanding the total debt be paid. It is strictly a bookkeeping or accounting procedure within the bank or loan company. Now, I mentioned an exception, and the exception is that oftentimes if a bank is charging off a loan, in conjunction with that, it will stop the accrual of interest. The reason being that relieves them of their obligation to send monthly statements under Regulation Z under the Truth in Lending Act. And however, it does not relieve a borrower of the borrower's obligation to make monthly payments where the loan requires it, as it does here, and specifically says in the loan agreement. So that's why you have a static balance, because the loan was charged off. So it would, as SLS's representative testified, it was the outstanding balance. It was the past due balance plus the outstanding principal, because the entire loan was charged off. But since there's no interest accruing, that's why the amount was the same until it was accelerated, and the portions that were past the statute of limitations fell off, those portions of those payments. So if it's accelerated,
however, for instance, there was this 11,000 and something dollar demand letter with that represented the accelerated debt at that time. Right, correct. So you don't have the next letter would have had a higher number for the interest.
Well, if interest was accruing, so for example, if it's accelerated before it's charged off, the interest would keep accruing, then it's charged off. While not strictly required to stop the accrual of interest, that is often what happens, because that way the creditor does not have to send monthly statements. But if the charge off happens first, as it did here, that essentially prevents the balance from increasing, but it does not, as time passes, the portions of the installment payment.
You're losing monthly, you're losing an amount from the statute of limitation.
Correct, Your Honor. And that's exactly what happened here. So we believe the letters, the prior letters, are clear that they did not accelerate, but even if even if the court were to disagree, any ambiguity has to be read in favor of not accelerating under the Tarkio case as adopted by In re Crystal Properties. And so therefore we believe the trial court ruled correctly, but even if separately, they would still, the statute of limitations is affirmative defense. So the obligation was on Ms. Brazelton to prove each element. In order for a letter from an agent to accelerate, there has to be authority. The only evidence of the authority came from the agent itself, which cannot establish apparent authority as a matter of law. That's Stone versus Palms West Hospital from the Florida 4th District Court of Appeal. And there was no evidence submitted that of any actual authority or ratification other than that of Student Loan Solutions with respect to the February 2022 letter. So that is the only letter that could have accelerated this. And in the reply, Ms. Brazelton suggested that this was, appeal by ambush. If they'd known we were going to raise this issue, they would have included the deposition transcript as part of the record of Williams and Fudge. I believe that argument is a red herring for 3 reasons. First, Williams and Fudge did not have the authority, so that evidence doesn't exist. Second, I defended that deposition on behalf of Williams and Fudge and have reviewed the transcript. The question of the authority to accelerate never came up in that deposition. The authority question was limited to whether they had the ability to collect on behalf of Bank of America and Student Loan Solutions, which is not in dispute. Third, even if such evidence had been in there, it would still have been incumbent upon Ms. Brazelton to enter that evidence at trial. And while Mr. Bannon did question Mr. Rue about portions of the transcript itself was never offered in evidence, never made an exhibit. And so in short, there was no authority. There was no evidence of any authority. The only evidence is or potential evidence, I should say, is the letters themselves, which cannot, as a matter of law, accelerate.
Well, even if, for instance, the question of whether there was evidence of authority, right? Again, would that go to the authority of the collection agency to accelerate as a matter of law, or to the intent of the lender to accelerate or not? I mean,
Both.
It would go to both, correct?
Yes, because
So the absence of evidence of that authority, something you could argue that goes to the intent compared to the later letter where they said it's accelerated.
yes, Your Honor, the later letter, there was the actual authority, there was the intent, and so there was testimony of the representative of Student Loan Solutions to that effect. And even if for whatever reason someone thought that didn't establish authority, at a minimum, it establishes ratification. So that
And
letter,
the letter that the letter that included the actual language of the acceleration said that SLS hereby accelerates. And this was sent by the agent, but says SLS accelerate.
yes, Your Honor. And I would also note that in addition to saying that, it says that consequently, $11,694.16 is now immediately due and owing to SLS. So that immediately due and owing language is not present in any of the other prior letters. And so while the word accelerate may not be strictly required, this other provision makes it clear and unequivocal that this is intended to be an acceleration letter and is an acceleration letter. The prior letters don't have that. We believe the trial court properly interpreted those letters, and that if there's an ambiguity, we cite case law in our brief that ambiguity interpretation becomes a question of fact. Trial court resolved that fact in favor of Student Loan Solutions. That finding cannot be disturbed unless appellant can demonstrate it's clearly erroneous. Appellant has not even addressed that standard. Therefore, believe the only option for the court would be to affirm the judgment, be it for the reasoning stated by the trial court or on the tipsy coachman doctrine for any other reason supported by the record.
Okay. Thank you, Mr. Grassi.
Thank you, Your Honor.
Bannon, you're up for 5-minute rebuttal.
Thank you, Your Honor. Initially, it's our position that the standard is not subjective. It's an objective standard for the court to apply based off of the facts and circumstances per trig. So it's not whether the debtor intended or thought it was an acceleration. It's whether or not it was actually an acceleration based off of the facts and circumstances, which in here, based off of the representative's testimony, is again, there is testimony from the representative that this amount that they were demanding repeatedly and asking and demanding that she pay included all principal, interest, and late fees and would have fully satisfied the obligation if done. Clearly shows an acceleration. Now, with respect to charge off versus acceleration.
If I may, Mr. Bannon, because I pulled up the earlier one, the one of 2017. Mm-hmm. I know when you're going to have an acceleration, it has to be very clear. The whole amount is due right there. In that letter, in the 2017, it's really interesting. It says, if you notify this office in writing within so many days that you dispute the validity of the debt, here's this language, quote, this office will obtain verification of the debt. So the fact that it's open and it's not specific, does that counter your argument that this was an acceleration letter?
Well, and again, the issue here is that is the validation portion of the requirement, the FDCPA portion. That's what's required within that. But we have numerous other communications that don't contain that language. So you'll have other letters from Student Loan Solutions sent on September 2014 through November of 2017, which is the letter that you're mentioning currently, that with letters that don't contain that information, specifically letters that simply say we represent the above creditors to collect the total amount from you in connection with the delinquent debt. And the other thing is this amount stays static. So it isn't that each month you're getting a higher amount or a lower amount. It is the same demand over the course of 3 years, over 3 years, of $30,548. So again, that validation portion, while required by the FDCPA to allow them to dispute the debt, doesn't change the fact that the other letters that don't contain that specifically demanded payment of an amount that could not be owed, Your Honor, without acceleration. And that's the part here that is problematic, is that when they caption this as charge off versus acceleration in their answer brief, they tactically admit that it is acceleration. So they bring forth a definition from Black's Law Dictionary that they claim is the definition of acceleration, and that is the advancing of a loan's agreement's maturity date so that payment of the entire debt is due immediately. That is exactly what was done here. The representative testified in no uncertain terms that the amount they demanded would have fully satisfied.
Well, that kind of goes without saying, because the law required them to put the total amount of the obligation under the note in the letter. So of course that would have satisfied it. It didn't mean that they were demanding it right now. That's a different thing.
Well, it's our position that they were demanding it right now. As the letter specifically says, we're here to collect the entire amount from you in connection with the delinquent debt. They also cite to the Lippincott case in their brief, which talks about charge-offs versus accelerations. And in that case, in the block quote, it says the charge-off process has nothing to do with contacting the debtor and demanding the total amount be paid. That is what acceleration would be. And they caption it as it's one or the other. It's not. These things are not mutually exclusive. You could arguably not accelerate a debt or not charge off a debt and accelerate it. You could do any one of those things. So they're not mutually exclusive things. And I think the reliance on the new Dye case, and I know the court's been begging us to provide some case law that might provide some guidance.
It would have been good in the briefs, I'm telling you.
Well, the new Dye case cited by opposing counsel and the appellee has negative history, and it's negative history that is on point because it specifically.
But that negative history didn't make it into the brief.
Correct, but it is a student loan solutions case. It is 2022 Westlaw 971183. It's a United States District Court from Maryland opinion in 2022, March of this year. And it involves a class action filed against student loans.
So today is the first time you're citing this case.
Correct. It's
well, that's not how we do it in Florida.
No, I'm saying you're asking for a case. I don't think there is a case.
I'm noting that I wasn't given a case, and I asked for a case, and no one said one. And now you're citing a new case.
We'll move on.
What we used to call, well, never mind.
And again, the agency argument, this idea that we had to present evidence of agency, I think is a red herring. All that's required is that Student Loan Solutions authorize and Bank of America authorize Williams and Funch to send these communications and employ the language done. There is no evidence that they went rogue, that they weren't entitled to send these communications. Again, what is or isn't acceleration is for the court to determine based off of the facts. The facts here are that
your time is up, Mr. Bannon. You need to wrap up. All right. Thank you both. In order to leave our virtual courtroom and disappear from our screens, you need to click the button in the lower right-hand corner of your Zoom, which might be a button that says leave, or it might be a pictograph of a figure going through a door.
Thank you, Your Honor.
Thank you.
You both.